Hey everybody, John Skiba here from the Consumer Warrior YouTube channel. And in this video, I'm going to share with you the number one tip of anything I do on my channel. This is the number one thing. If you've been sued by a debt collector, this is what you need to do. You need to file a written answer. We're going to talk about why most people don't do that, how it is that you can do that, and I'm going to give you some very exciting news on a real professional way to get this done to make sure that you don't end up with a default judgment. But if this is your first time here to my YouTube channel, please go ahead, click subscribe, check on that little bell. That way you'll be notified each and every day when we put out new videos that'll help you deal with serious debt problems. All right, let's talk about debt collection lawsuits. Debt collection lawsuits are second in most local courts, only to the criminal docket. Courts are flooded with lawsuits, and particularly over the last 10 to 15 years, junk debt buyers, companies like Unifund, Portfolio Recovery, LVNV, Resurgent, all these big companies, they go and they purchase debt in gigantic volumes. Millions of lawsuits are filed against consumers each and every year throughout the United States. And the statistics show that over 95% of these lawsuits end in a default judgment. That means that the people did not respond after being served with the complaint and summons. This is terrible. This really destroys any chance of being able to deal with this in an effective way, because if you get a default judgment against you, not only do the court give them everything they're asking for as far as the underlying debt, they often add interest, attorney's fees, and I've seen a $1,500 credit card balloon into a $10,000 judgment that continues to accrue interest. So if you want to have any fighting chance of being able to deal with the debt, whether it's to settle it or to get it thrown out, you must file an answer with the court, and you have to do it timely. In this video, I'm going to talk about how you do that, what's important to put in it, and maybe more importantly, the types of things you should not put in it. I've been doing this for 20 years in the state of Arizona. I've done thousands of these. I've dealt with a lot of cases. I've dealt with a lot of different debt collection attorneys, different debt buyers, and I'm going to share all this information with you today on why it's so important and what you need to do in filing an answer. And not only that, I'm going to share with you below here, there's a link to a company I've partnered with, SoloSuit. SoloSuit does incredible work. They have used all this technology to be able to help you to put together an answer, and not only put together the answer, but to actually file it with the court and have an attorney review it to make sure that you're doing it right. That link's going to be below. That'll help you out. I'm going to talk a little bit more about that as we get into it. Okay, so let's go ahead and jump into how to draft an answer to a debt collection lawsuit. Okay, so what we're going to do is we're going to actually look at a typical summons and complaint from a debt collection lawsuit, and we're going to go step by step as far as what kinds of things need to go into responding in a written answer to a lawsuit, and probably more importantly, what kind of things should not be going in there. So this is a typical run-of-the-mill complaint. This one is filed in Sholo Justice Court in the state of Arizona. And so I want to walk you through really what you're going to see, and sometimes they're called petitions in different states. Typically, they're called a complaint. And so what you're going to see here in the upper left-hand corner, this is the contact information for the law firm that's representing the plaintiff. The plaintiff is the one who actually has the claim. Sometimes I see people get that confused. They think that the law firm is the one who owns the debt. Sometimes that's true, but rarely. Usually, like in this case, the Gerstel law firm is a collection law firm in the state of Arizona, probably do the most collections of any, and they just have the listing of their contact information, the attorneys, that kind of thing. Then in the middle here, we have the court that it's in. Arizona requires that the address of the court be there. A lot of states don't require that. But this is helpful because this is going to help you to know where you need to send your answer, because this will give you the name of the court. Then on the left side of the caption, you'll see the plaintiff. In this situation, we have capital one, creditor that's filing the lawsuit. And then the defendant, I've got this one redacted because this is an actual complaint. This would be your name if you're the consumer that's being sued. Case number, which is important because you're going to need to put that in your answer to be able so that the court knows how to do it. And then this is the title of the document. So this document is called the complaint. Your document will be called the answer. As I mentioned before, I'm going to put a link below, or SoloSuit. They help you draft the actual document itself. So you're not going to have to put all this together, but it's just good to know really kind of what it is that you're looking at and then what your response will be. So these complaints, particularly for the large law firms that are handling a lot of collections, you're going to see that these are just kind of cookie cutter boilerplate. They'll change the name. So here we have the creditor's name, but you'll see they'll just refer to defendant throughout. They aren't even going to list the specific name. And then there's going to be various numbered paragraphs throughout this. And so like here, you're going to see they're going to get into the claims, breach of contract, account stated, which are very common in debt collection cases. And then here, this on the last page, this is what's called the prayer for relief. This is what they're asking for. So in this particular lawsuit, they were suing for about $1,534. They want costs, they want interest. Here they're asking for 0% interest, and then they just throw in a thing for anything else. So when you respond to an answer, the way to look at this, the answer really is, this is just a list of numbered paragraphs with allegations that the plaintiff, in this case, Capital One, has against you. So they have 17 numbered paragraphs with different allegations. And the court wants you to know whether you admit or deny what it is that they're alleging in each of the specific numbered paragraphs. Now, the biggest mistake I see people make when they are filing an answer to a lawsuit is they try to use it as their time to kind of tell their side of the story. Or the second biggest thing I see is where they want to put in settlement proposals. So this case, they're being sued for $1,500. They want to come in and say, no, let's sue, I'll offer $500, that kind of thing. So it's not something, you don't want to do that in the answer. You don't want to tell your side of the story, really. Really what the court wants to know is there a dispute? Do you agree with everything they say, everything that they're alleging here, or do you deny it? And so the three most common and usually what I say preferred answers are you can admit the allegations in the specific paragraph, you can deny the allegations in that paragraph, or you can essentially say, I don't know. You can say, I don't have enough information, so for now I'm going to deny it. And so if you use like the solo suit template that we're talking about, if you use them to help create the answer, they're going to ask you some questions and walk you through what your response is to each of these documents, and they'll kind of put it in the legalese. But really what you're looking at is admit, deny, or you lack sufficient information, so you're going to deny at this point. And that's all you need to do. Now, it is important, one, that you be accurate, that you be honest in what you're responding to. But I always say you need to be painfully accurate and incredibly honest. And what I mean by that is, so let's say here in paragraph number 12 down at the bottom, it says the defendant owes to plaintiff for the purchase of goods, wares, and services the sum of $1,534.69. If you don't have independent knowledge that number, $1,534.69, is 100% accurate, my opinion is that you're fine to say that you don't have enough information to admit or deny that, and therefore you're going to deny it. A big one you're going to see with junk debt buyers is they are going to put a paragraph in there that's going to state that they were assigned or that the original account was transferred to them by the original creditor. Unless you have independent knowledge that it actually happened, and most people do not have that knowledge, then that's something you would say that you lack sufficient information and therefore you're going to deny it. So when you review this, you should not make any assumptions on behalf of the creditor. You need to be responsive, if it's something like this is an original creditor lawsuit. So if Capital One filed this complaint, and if you had a credit card with Capital One, if they provide you the last 4 digits of it, then yeah, you should admit that. But if they said that they transferred it to LVNV funding and you don't have any information on that, that's something you can either deny or say that you lack sufficient information. The other thing to be aware of, usually with the complaint and the summons you will see, or the complaint, you'll get this copy of a summons. The summons is very important because it tells you how many days you have to respond to the complaint. So in paragraph 2, this is an Arizona court. So it says that if you live within the state of Arizona, you have 20 calendar days. That means that includes weekends to file an answer. If you were served outside the state of Arizona, you have 30 days. And then like here, it says the court's located and it gives an address here in Sholo, Arizona. And so that tells you where you can send it, where you're going to send it as far as the physical court, and then the time frame you have to respond to it. It's also important to look at and to understand that you need to send a copy to the other law firm. Here, this Gerstel law firm, the court typically does not do that. So if you're doing this on your own, you're going to need to file the original with the court. There's usually a filing fee in most states that you're going to have to pay, so you need to be aware of that. Be prepared when you go in to pay the filing fee, and then you need to mail a copy to the attorney for the plaintiff. So my recommendation is always to have the original and 2 copies. Take the original and the 2 copies to the court, file the original, have them timestamp the 2 copies, mail 1 to the attorney for the creditor, and then keep 1 copy for yourself. Now, again, if you use Solo Suit to do this, they do all this for you. You'll fill out the information, they'll draft the answer, they'll have you review it, and then they file it, and they actually even pay the filing fees and mail it. They do all that for you. It's a real simple way to do that. And they have an attorney review it to make sure that what you're putting in there is accurate. So that gives you some peace of mind that it's being done right. So that's all it is. That's all that the answer really is. It's something where a lot of people stress out about it. And like I said, people really actually err on putting way too much information into the answer. That will come later in the lawsuit. But for now, all you need to do to avoid default is to have that answer filed with the court. You do that, and then it's going to lead to other areas of discovery and motions and things like that. But you can buy yourself a lot of time, avoid default, maybe even get a good settlement in the process by just filing the answer. So hopefully that's helpful to you. If you are in the state of Arizona and you want help with this, my information is below. Like I said, if you're anywhere else in the country, I partner with Solo Suit. They do a great job of helping you to draft the answer. It's really high tech as far as how they do it, and they actually have an attorney review it for you, and they do the filing for you so that you know that it will be done right. But if you have any questions on that, put them in the comments below. I do review them. I'll try to get to them. I appreciate you watching today. We'll catch you next time.